Okay. Hi, everyone, and we are live. So welcome to today's meeting of Foreclosure Bench Bar. As you're all aware, Judge Feo is still on the bench, but she should be joining us shortly. So she did ask that we just get started without her, and hopefully she'll pop in a moment. I'm going to note for the record that Judge Abrams sent his regrets. He's not able to join us today. And just a quick attendance in no particular order except for that which you all show up on the screen. So Judge Rohrbach.
Here.
Judge Spader.
Here.
Attorney Janaris.
Here.
Attorney Pocklington.
Here.
Attorney Gentis.
Here.
Attorney Sternberg.
Here.
And Attorney Salato.
Here.
And Attorney Schmidt also present. And as I said, Judge Feo should be joining us hopefully shortly. The first matter of business we have is the minutes of November 30th.
Quick question for you on that. I went through my emails and I didn't see that I had it. So I don't know if I just didn't get that email. I don't see that I've got those minutes.
Sure, let me forward them to, does anyone have the minutes? I'll go ahead and forward to the whole group. Okay, and you'll all have to wait until it gets through our security so that you can view it.
I'll make a motion to approve the minutes as presented.
Thank you, Your Honor. Do we have a second?
Second.
Thank you. And all those in favor?
Aye.
Any abstentions?
Give me 2 more seconds. I'm on the last.
Absolutely.
They do match my recollection of the meeting, so I will vote in the affirmative as well.
And no nays, correct?
Correct.
Okay, moving on to old business. The last time we met, we had before us the property calendar notice, and there were, I think, a couple of comments that people had, but we wanted to take a minute to look at those. Met in November. There was an additional change to calendar notices. So the calendar notice as updated for foreclosures, it either goes out saying that you'll get a later date for an in-person or a remote hearing. But to my knowledge, New London has gone back to being fully in-person as of early January. So their notice has been updated to indicate that they are to appear at court on that date. So that's different from the rest of the notices that go out for short calendar for foreclosures. And if any other districts make a determination that they're going to go to an in-person same day short calendar for foreclosures, we would expect them to contact us. We did let the clerks know that it was necessary and imperative they do so that we can make the same update to their calendar notice. Hi, Your Honor.
Hello, my apologies for being late, folks. I let Becky know, I emailed all of you or messaged all of you to let you know that I was still on the bench, and I've just now taken a recess so I don't miss the entire meeting. So, but Becky, thank you so go ahead. I don't know where you were. So
we had actually just gotten started. The minutes for the last meeting were approved, and regarding the property calendar notices, we didn't really have substantive conversation the last time we met, but there were some concerns with some perhaps suggestions for the updated notices. But I was informing the group that since we last met, New London has made the decision that they would return to an in-person same-day foreclosure docket. So their calendar notice was updated accordingly. And we also, in updating the clerks, asked that if their district makes the determination to return to an in-person same-day foreclosure docket, that they let us know so that we can coordinate updating the calendar notice appropriately.
What does that mean, same day? You mean like the same day it would have been remote, you do it in person?
It means that it operates substantially like it did pre-COVID. You get a notice, and if your matter is marked ready, the instruction is to go to court on that actual calendar day. So there's not a delay of a few weeks to schedule the matter either in person or remotely.
do the judges, I know the practitioners know, but do the judges know what's happening now with ready markings? and what that means, why Becky's saying same day?
No, that's
I'm
why I
going to
asked the
guess.
question.
Yeah.
Yes.
So what's happening now, and you folks on the other side of the bench, you can please, if I don't state this correctly or you feel it needs to be changed, please let me know. Oh, and welcome, Attorney Gentes. You made it. I thought you had a Supreme Court argument today, so nice to see you here. But in matters when they mark things ready, there would be a notice being that it wouldn't be that same day. You wouldn't mark it and then be on that Monday. There would be a delay, and sometimes the things don't get scheduled. At least in Hartford, sometimes you'd get it. It would be scheduled for sometimes 2 weeks, folks? 2 weeks ahead. Yeah, so it delayed things, and I know some folks were frustrated about that. Whereas, of course, with the regular pre-COVID, if you marked something ready by the deadline on Thursday, it meant that it was on for that following Monday. That wasn't always the case with foreclosure. You'd get a date saying you're going to be on this other day. So that's why when Becky says same day, she just means it's going back to pre-COVID live short calendar.
Has there been any pushback from the lawyers saying, wait a second, I got a non-appearing defendant. I got to drive all the way to New London to put on a show when there's not even an appearing defendant?
I'm
Or is
not
that just-
yeah,
We were very used to that, so that's nothing out of the ordinary.
I mean,
I'm
it's kind
sorry?
of like, he said they were used to that pre-COVID because that's how short calendar operated. I guess we'll
No, I
find
get
out.
it.
if people
We were
push
all
back.
used to it. I just didn't know whether, I mean, it's one thing. I can see if you have an appearing defendant, I, as the judge, if I have an appearing defendant, prefer to see them in person than on the screen. But if a non-appearing defendant, it just seems like it might be not the most economical use of resources to have people drive hither and yon for that exercise that we're all familiar with. I mean, I guess it's always nice to have the note and mortgage handed to you in real life rather than searching through the exhibits and scrolling back and forth. But I can't think of other immediate benefits.
Yeah. And I guess they must have. I guess we'll find out from when New London goes back live if there's any pushback. But Becky, I thought there was somewhere else other than New London that was doing that. No?
I am aware that there are other districts that are holding their dockets largely in person, but it's not the same day that the calendar notice is for.
Okay.
It has that you'll get a future hearing in person at a later date and time.
Gotcha.
And who makes the call? Is that like the HA?
To my knowledge, in New London, I don't want to misspeak. I believe it was the PJ, and then in consultation with Judge Bellis, was made aware of the request.
Okay.
And the determination was made.
Okay.
Becky, when is that effective as of? I just spoke to the attorney in our office who handles New London, and she was not aware of it going back to in person. And I think James was on the same page.
Yeah, no, this is the first time hearing of it. We've got remote hearings scheduled next week and I think the week after as well. Haven't heard anything about. I know housing evictions have been back in person for quite some time, but not foreclosures.
Yeah, we
Becky
do
Becky
housing in
seems
person.
to be looking for a start date.
I know it was January, and I do know that they published a notice. I'm just looking to see where that publication was made. I do know there was some outreach to the bar, but let me just see if I can put my hands on it.
If you can't do it immediately, maybe you can make a note and get back to everybody with an email to let us know that. So that we don't, yeah, then we don't put you on the spot and take time watching you look at computer screens.
And if I may, this is foreclosure only, not other civil matters.
Right.
Okay. And yes, Judge Baio, we got taken first rather than third. So
that's great.
Surprised.
Well, it's good to see you here. Thank you.
I'm glad one of the parties didn't show up in the first appeal. So
there you go.
Thanks.
So does everybody have, though, a copy of the current property calendar notice? I mean, there may be some changes, so it might be premature for us to take the time, but I don't think it hurts to take a look at it and then at least send your suggestions to Becky. She and I can look at them and put together whatever comes in and put it on the agenda for the next meeting. I know that we had some on the foreclosure standing order, but with regard to the property calendar, everybody has the at this point, the most current version, right, Becky?
Yes, I believe so. And I do have a point of clarification for the last section when you have a moment.
No, go right ahead.
Oh, I did misspeak. I apologize. It's the foreclosure calendar is the only thing that's following the remote or in person at a later date scheduling. It's regular civil that they've gone back to
change my
in-person
note.
for. My apologies on that. There was some discussion on the other dockets, but they remain consistent with the rest of the state at this time.
All right.
That makes a great deal more sense because I can see, as Judge Rohrbach was saying, in terms of when you've got a defendant, when you don't, I can see a lot more things like contract collection where a debtor wants to show up and discuss it being in person, whereas, thank you very much.
Sorry about that.
All right. So if anybody does have any suggestions to make with regard to the property calendar notice, perhaps you can do the same thing in the manner that we've been following and send those, as I indicated, by way of email to Becky. She'll compile them, share them with me, and then we'll address them at the next meeting. Is that acceptable to everybody? Okay. Yeah, you got that, Becky? All right, and then you want to go ahead and start off with the standing order? Becky?
So the standing order remains as it previously was the last time that we met, and I know that there were a few suggestions. I believe Attorney Gentis submitted a few via email regarding, a lot of it had to do with the chronology of the order. Did Attorney Gentis want to address his concerns?
Did those get circulated to everybody?
I believe he emailed them to everyone.
Okay. So rather than going through them all, because everybody's had a chance to take a look at them, I'll just ask if there's anybody that had any feedback in response, if you agree, if you disagree, what you have to say, because that way we can see as a committee where we stand. Anyone?
I was impressed that the job you did on those, Attorney Gentis. I mean, it was well done.
Anyone else? Yeah. Does everybody agree? Do you? I mean, because with these, if there's consensus as to the proposals, then the next step is to send those in as recommendations. But I don't want to do that without hearing that everybody is on board with that, or if you have any input one way or another. If you need more time to look at them, that's fine too. But other than Judge Spader, does anyone else have anything to pipe in with?
The one observation I had was I'm not 100% sure. I see one of the tweaks that Jeff made. I actually personally philosophically agree with regarding grant of default on the bench, assuming that they were timely filed. But I think it may run counter to Judge Bellis's intention in changing things the way she changed them. So I don't know whether we want to be walk a little more carefully there. I don't know.
Good point.
But that may be a bigger discussion to have offline amongst the judges rather than involving the practitioners. But ultimately, at least from our perspective, there's no reason that with the practice book authority to grant a default simultaneously with the entry of judgment, why that was necessarily taken away. But I understand from a judicial efficiency perspective, Her Honor's desire to have that was done primarily by the clerks as opposed to by the judges.
Anyone else? Valid point. All right, so nobody has anything to say. There's like crickets here now. So I mean, I don't want to put anyone on the spot, but I would like to hear do you agree with what Jeff put in his very detailed submission? Do you have anything that you, like James indicated, that you think is a talking point that we need to explore further? Because I don't want to submit something on behalf of the committee if the committee's not all on board with it.
The only thing that I'm seeing, Claudia, and I'm honestly, I may have looked at it when it came through originally. I'm looking at it now. It's always weird to me when another party marks my motion ready. It's like, wait a second, it's my motion. How come another party can mark it ready? I also understand that you can gum up the works by filing a motion and then never claiming it. And it's like, well, how come we can't move this case because so-and-so filed the motion? It's never been claimed, but maybe that's like old news and we should just let anyone claim a motion once it's been filed without regard to whether it's yours or not.
Okay, wait a minute. Now, maybe I'm the one that's behind the times here, but I don't, I know at least in Hartford and New Haven, unless they changed it, only the moving party can mark the motions ready. Because that, is that not?
I hope I'm looking at the right email from Attorney Gentis, which was like a marked up version of Judge Bellis's standing order.
The
Oh,
practice
wait a
book,
minute. Go ahead, James.
my understanding of the rule is that once a matter has gone off the calendar, as printed on the regular docket and gone off the docket due to inactivity, any other appearing party has the ability to reclaim it to the docket to essentially force the issue so you don't have a motion sitting out in limbo indefinitely.
Oh, you're talking about reclaims. I'm sorry. I thought you meant about the initial marking it ready, because I mean, I know that we generally wouldn't accept the markings from someone other than at least I know my clerks for me, and if it came to me, I wouldn't. But you're saying that to reclaim it because it's hasn't come up. I understand. And Attorney Rohraback, Judge Rohraback, what was your issue with that? I'm trying to, I
was looking at an email from Attorney Gentis, which marked up a short calendar order for property and foreclosure matters. I'm guessing that's the standing order, right? Or
hold on.
I think I moved language on that, but wasn't trying to change it.
Yeah,
no,
I didn't.
You didn't
now
change
I'm
it. You didn't change it. My question goes to the existing language. I mean, you did change it, but not in a way that affects what I'm talking about.
Got it. And I agree with Attorney Pocklington. Once it's reclaimed, then any party can mark it.
Right.
It's the first time, you don't have control over, it's the moving, but then, yeah.
Yeah, Pratt's Book 1113, subsection C.
Right. So
I get all that. I'm just looking at the standing order that Attorney Gentis said on January 5th. It doesn't say, it says motions that are arguable that were marked ready by you or another party. I guess that maybe baked into that is that the original filer we're only going to accept a ready marking from the original filer in the first instance, and only after that's happened can somebody else mark it ready.
So are you saying you don't think that language is clear?
No, I probably should just shut up because it's not clear to me. To me, it suggests that somebody whose motion it is not can mark the motion ready.
I see what you mean on part one,
right
there, where it says if a party wants to ask the court, mark the motion, take papers, that implies that the non-movement can mark it, take papers. At least that's what I think I'm agreeing with.
No, I'll shut up. It's the first paragraph.
No, that's important. That's why we need to talk about it.
Well, so I'm looking at the email that was sent by Attorney Gentis on January 4th, which is a marked up version of short calendar order for property and foreclosure matters.
Right. That's the one. That's what we're talking about.
Right. And it starts by saying, unless otherwise ordered by the court, the following orders apply. Motions that are arguable that were marked ready by you or another party will be scheduled.
Right. And I think his proposal was to take out the words you or another.
His proposal, he said by a party. He just cleaned up the language. But it still suggests that any party can mark any motion ready without regard to whether it's that party's motion or the other party's motion.
I understand what you're saying, but do you think, and I get it, if taking Jeff's proposal though and taking out you or another and just putting
Look, Jeff's proposal has nothing to do with the issue that I'm identifying.
No. I'm asking if you think that fixes the issue. Because it doesn't say
says
you or
a
another.
party. If he said that were marked ready by the moving party,
Okay,
Well, but it's not necessarily the moving party because of the reclaim issue, perhaps by the appropriate party or by
that's
an
good.
appropriate party.
because yeah, that's the thing is like without putting
again,
that all in
by
there.
a party, by a party eligible to claim the motion.
All right, so
I don't think
I
it
get
amounts
it.
to a hill of beans, but
no, it does. It does.
Or
It
maybe like
does.
properly marked by a party, because that's usually the clerk is
That's a
the
good-
first gatekeeper in reviewing whether or not it's the move-in's motion to mark or whether anybody can do it pursuant to practice book. If the clerk misses it in calendar prep, it's the judge's,
Right.
reviewing of it.
Is that a good compromise? Actually, I like that. Properly. Do you like that?
works for me.
Okay, great. Okay. Any other suggestions or input regarding Jeff's cleanup? I mean, I like that it was made more concise and I think a little bit clearer.
One question I wanted to raise in light of the new electronic exhibits is whether the language on page 2 about the original documents warrants some modernization. Just as it currently reads, and this is based off the presentation standing orders, the original note, mortgage deed, and assignments of mortgage must be uploaded individually as an electronic exhibit using the appropriate title, etc. With them just being electronically updated, obviously the practitioners upload copies of the original note from that they're holding as bailee, but regarding the mortgage and assignments, are certified copies of mortgages off the land records still a necessity given the fact that most land records are online and we're just uploading electronic copies? And we've also seen recently some judges taking the original, as it applies to original note, and asking to see certified copies of assignments as well, which hasn't traditionally been done. So I'm wondering whether there is reason to update that to, or the original note obviously needs to be in plaintiff's counsel's possession as bailee, but regarding the mortgage and the note, or excuse me, the mortgage and the assignments, whether there's an opportunity to modernize.
Your representation to the court of what you are uploading is that you are uploading a facsimile of the original in your possession. So I still believe you have to show me that a certified copy to demonstrate that that's what's on the land records. A certified copy is evidence. It's the requirement that you need to show me. So I still think you need to tell me you've got the certified copy. And if you're copying the certified copy, I think you need the certified copy because that's what I need to adjudicate. I need the actual evidence, and the certified copy is the evidence of what's recorded on the land records if you don't have the original.
I agree with Judge Spader.
Totally fine.
I do.
With how many town clerks are going to online land records, it was just a question.
No, but the original mortgage ought to have a stamp on it. It ought to have the volume and page on the top of it. So in the olden days, when you brought me the original mortgage, it didn't need to be a certified copy. It was kind of self-authenticating by virtue of the stamp that was on it.
But that's if you have the original. I think what Attorney Pollington was asking is the copies you can get off the land records now. Do we really need the original?
Well, yeah. So I either want the original,
or more to the point, if we have access to the electronic online land records as maintained by the individual municipality.
Yeah, I don't think that's
electronic
enough.
copy, whether it's still sending a physical searcher to get the town clerk to hit print and stamp would still, but we're
But
good.
the difference is they are stamping it. That's what
Yeah.
So I agree with Judge Spader. I know it might be easier, but it isn't necessarily accurate to not have that stamp.
And
It's the
meanwhile,
plaintiff's
the Attorney
burden to prove their
Pollington
case.
actually is in possession of the original mortgage,
Right.
which is not certified. He just got a return to
Exactly.
the mortgage.
Right.
And he
no, it
uploads
was
it and tells
primarily a
us,
question about certified mortgages with the
Got-
ease of
got it.
online land records these days, now that town
Yep.
clerks are really moving in that direction. Thank you.
Attorney Generous, you have your hand raised.
I actually wanted to address that paragraph as well, but it wasn't specific to what Attorney Pocklington was mentioning. The sentence that Jeff had highlighted here, electronic exhibits uploaded in order to obtain judgment of foreclosure will be sealed by the clerk at the time of hearing. I know some courts have been sealing them before the hearing, which makes it very complicated when the judge is looking at the documents and we can't see what they're looking at because they're sealed, so we can't get to them. I'm not sure why exactly they need to be sealed, because I feel like only parties logged into e-services on that case can actually see the exhibits to that file. So I'm not sure about the sealing of the exhibits in Edison, because I know Hartford for a long time, all of the exhibits were sealed prior to the judgment hearing. So when we would have a remote hearing and the judge was asking a specific question about the exhibits that have been uploaded, we couldn't actually see what they were looking at because they were sealed on our end.
Oh, interesting. See, I wouldn't have any way to know that that is the case. And I see that Jeff actually has that question here as well. Why would these need to be sealed? Does anyone have anything to say about that? That's a really good point.
I think Jeff's question might have been slightly different because he was referring to redacted attachments to summary judgment motions. So the exhibits that are uploaded as exhibits are not redacted in any way. They are the originals, so the loan number is on them, everything is on them.
Well, Jeff, let me ask you, because I didn't read your comment that way. He said, why would these need to be sealed? And then said, save for redacting the number on the notes is that would normally be part of. So I think he was saying, other than that, why would they need to be redacted? Did I read that wrong? Is that not what you meant?
I agree with your reading. And so I had the same question basically as Attorney Generous, which is, why would we seal these? These are normally just up for grabs. And if it's a matter of just, especially, I didn't know about Attorney Generous's other issue about like the lack of accessibility hearing. So all the more reason to not seal them. That's what we're saying.
I certainly understand the court's concern about anyone being able to see the loan numbers and personal identifying information on the documents, but I don't think that based on the way this is done as exhibits that are only viewable when logged into e-services on that particular case, I don't know if it's necessary or not. I know that we've had issues at some points where the exhibits were sealed when they were filed. So once they were filed, you would go into the exhibit tab on Edison and it would say exhibit sealed, and there was no link to any of them. So you couldn't see them anymore. So, and that was happening prior to the judgment hearing. I think it was happening when they were actually uploaded to the court. So not only did we not have access to them, opposing parties didn't have access to them either. So they couldn't see what was being uploaded. So, I think that kind of defeats the purpose of the good old days when we were in person. You could hand the physical note to the opposing party, they could look at it and hand it back to you. But if they don't have access to it in e-services, I'm not sure that's a great alternative.
Right. And but you understand, you two are agreeing. Jeff was just saying, other than that carve out. So let me ask you this. I think it makes sense when people upload them wrong and upload them into the regular docket. Obviously, those need to be sealed and that happens. But when they're uploaded correctly, does anyone have any other input? I see Judge Rohraback raising his hand.
I just, as a paranoid judge, I've gone to judgment on foreclosure. I've looked at the note and mortgage. Over time, I've seen enough social security numbers and just weird stuff show up in these documents that shouldn't be there, but they are there. And rather than me taking the time to go through and making sure there's no smoking gun, it's just the clerk says, you want those sealed? Yeah, seal them. Because what harm is there? It's like an insurance policy that if there's something bad there, it's not going to leak out into the world. That's the way I look at it. Like, who cares once you've gone to judgment whether the exhibits that you relied on? In the olden days, the court didn't keep those things. We handed them back to the lawyer. So, okay, good enough for me. So that's the way I look at it.
And I'd be
I can speak
concerned.
to the system. Oh, sorry, go ahead.
I'd be concerned. It's George's comment about needing to be logged into e-filing only available to the parties. If we're looking at this primarily from a lender and homeowner perspective, that's one thing. But keep in mind that that pro se judgment lien creditors can request access through e-filing. Other parties, as long as an entity has an interest on the property, on the land records, they're going to be named in the action, and they would have the ability through pro se access to e-filing to see all the documents. I wouldn't want a homeowner's, let's say a mechanic lien holder to be able to come in and view the note and see the borrower's unredacted social security number because they're no longer sealed. But as long as they're sealed, that level of personal identifying information is kept out of the hands of parties that don't need it.
I think based on the way that this wording is currently set up, they can do that currently. It says that at the time of the hearing, they will be sealed, but when they're uploaded, they are not sealed. So I think they would still have access to them up until the time of the judgment hearing. So I don't know if there's a way around that based on what I've seen. My only concern was that in certain circumstances, and I don't think it's really happening anymore, but for a solid year and a half period, everything we were uploading as exhibits were being sealed before the judgment hearing. So then once the judgment hearing was taking place, no one except the judge had access to the exhibits that were uploaded in the case. So if there were specific questions about an assignment or an allonge or something like that, we could look in our file at what we had as the original, but we weren't sure that that was exactly what the judge was looking at.
So Attorney Generous, was that at the beginning of this whole remote process that was happening?
I would say up until about 6 to 9 months ago, this was the case in Hartford, at least.
Oh, really?
We were having issues where we could not view the actual uploaded exhibits because they were all sealed prior to the judgment hearing. I know this specifically relates to Judge Bail. A lot of times when you had questions about assignments or mortgages or a page was missing, I would have to go back into our actual file and not look at what was uploaded on Edison and just hope that they were the
I
same
was totally
thing.
clueless.
So,
I had no idea that you weren't looking at the same thing that I was.
I can lend a little bit of background as to the exhibit system itself. So at the time that it was built, it was COVID. It was to aid the court in remote proceedings because we needed a way to have the judge be able to review the documentation. Like Judge Rohraback said, in a physical setting, those are not ever documents that the court kept. And the way that the exhibit system works is that the clerk has to mark something ID or full, just like a regular exhibit, so that the court can view it. So upon the marking of an exhibit as ID or full, anyone can see it at a clerk's office PC. So your courtside trials that are remote, all of those exhibits that are ID or full, a member of the public can come in and use a courthouse PC and look at those exhibits because we no longer have a physical exhibit envelope to give them. So we have to provide access to the public. It's not it was built intentionally so that you still have to come to the courthouse to view exhibits. You can't do it in your home using the public website. You have to have a login. So anybody who does have access electronically to that case can see exhibits, whether they're unassigned, ID, or full, which is why there is an order that they be sealed at the hearing so that after the fact, if somebody were to come to a clerk's office PC to look at those exhibits, they would not be able to see that documentation.
So George, your concern, if I'm understanding it, and let me just state it back and tell me if I get this right, is not so much with that rule, but that some of the courts, in particular, the example you gave, Hartford, was not doing that and was sealing them prematurely.
Yeah, I have no issue with the exhibits being sealed once the judgment hearing takes place. That's not a concern of mine at all. That makes perfect sense to me. And I know exactly what Becky is talking about, having been attacking Hartford. I know all about IV and full exhibits. Pre-COVID, the note and mortgage themselves were never exhibits to begin with. They were never handed into the court as exhibits. They were provided to the judge to inspect or opposing parties to inspect. So I have no issue with it being sealed after the judgment hearing. My concern only was that they were somehow being sealed before the judgment hearing. I don't know if it was automatic when they were uploaded, that they were just automatically sealed. Because if you went into Edison and looked at the list of exhibits, it would just show everything as exhibit sealed and you couldn't view anything. So I have no issue with it being sealed after the hearing or once the judge inspects the note and mortgage and asks any questions. My concern was just that I don't know that there was a standard procedure in place as to how it worked, because I know that this wasn't an issue in some other courts. But I think it was just however it was happening in Hartford, the exhibits were being sealed basically immediately when they were uploaded.
So I think it's a
Take
valid
that one step-
question. The initial question that Jeff posed, though, I think is a valid one. And thank you, Becky, because that at least provides us with, I mean, that's why I asked if this was at the beginning, because, you know, this is an evolution and everything was put in place and then we learn as time goes on. But I get what you're saying. So James, you had something else to say.
Yeah, just going back to the financial privacy concerns and with George's thoughts in mind, what may make sense is that they should be automatically sealed on filing and just unsealed for the purpose of the hearing.
Oh, yeah.
That way there's no window where a third, essentially a stranger to the borrower's financial situation could come in and look for things. And that also would allow us, there are times where we've all seen files that are prepped and ready to go to judgment and then are marked over a few weeks or over, a couple of even months in some circumstances, where those documents, if they were filed as exhibits, would remain open and viewable to the public, whereas automatically sealing and then unsealing for the purpose of the hearing and then resealing immediately afterwards would maintain financial privacy in a way that I think the order is intended and in the way the practice book intends.
That is a very difficult ask of the courtroom clerk. I know that being that I was involved in that process when we were moving everything to remote, that was one of my main concerns. I didn't want you guys had to give me the original documents and I didn't want you to redact what was given to me as an exhibit. But the exact thing that Becky said, I think, is what she said to me probably back in 2020. Oh, if those documents are there, anyone can just pull them off an information desk. I kind of remember having that exact discussion a couple of years ago. And then, dealing with Dean in Bridgeport, instructing him, here's how we got to do it. And Tara in New Haven, here's how we got to do it. We got to make sure we protect these documents from those that shouldn't have them. And quite honestly, the privacy concerns to me are much higher than any other issue. And I almost say, if something needs to be reviewed, you can ask the clerk to specifically open it up, unseal it during the hearing, but not as a general course, because you guys as plaintiffs, and I've got plaintiffs here, I know I've got defense counsel here also, but as plaintiffs, you file them at all different times. Sometimes they come out on Tuesday, Wednesday, Thursday, Friday.
Monday morning.
That not in my courtrooms, because they're too used to me marking them off when I review things on Friday and say, hey, it's not there.
Oh, no, we do it too. And it's still, or we're doing it too. And it was still happening. But
in terms of where we're at, as far as protecting the borrower's privacy and those documents that potentially might be up there, we don't know when things are coming in. It just might be best if we only open them up if there's a question at the hearing, as Attorney Pockman just suggested also, because I really do have concerns with those documents just being out there. And again, is it a 0.1% chance of anything potentially being viewed? Yeah, it is probably pretty minor, but that's still, if something is going to happen, I don't want someone to say it's because the judicial branch listed it on their website, even if it's not the exact reason. I don't want to take that chance. And I don't want to take that chance for anyone's privacy that is coming through our system. So if we can minimize those risks for the convenience to Attorney Generous on, one or two cases a couple months.
It's not my convenience, Your Honor. I'm totally fine with it. I just have problems addressing questions from the court when I can't see what the court is looking at. So
you do just fine.
I do my best. And Your Honor, I did just go back just as a science experiment. I went back and looked at a file that we had on calendar last week. And all of the exhibits are still not sealed in that case. So I don't know if this is an automatic thing that's supposed to be happening at the time of hearing. So,
I did a science experiment too of looking at some of Monday's cases that I already reviewed earlier today, and I see that just if I logged in just through e-services generically with my personal address number, I was not able to access any of the documents. I just checked that out in the background just to see what was out there.
Yeah, so I just logged in with our juris number to the case that we had on Monday. And what I would use to see, like I said, would be I'd open the exhibits and it would list the 4 exhibits, 3 exhibits, whatever it may be. They would all be listed as sealed. These ones are still accessible, at least to us. So I don't know what the restrictions are on who can see these, but I don't know if there's an automatic way that these things are supposed to be sealed at the time of the hearing, or what's supposed to be going on, but it doesn't appear to be that they're sealed now.
There's no automation in that system. There is a standard practice and the clerks have been made aware of it, and we can certainly reinforce that and remind them. There's been a lot of turnover in the clerks' offices. So the documents, as you upload them into the electronic exhibits, are not viewable except to people who have electronic access to that particular file, and obviously clerk's office staff. It's when it gets marked as full during the course of the hearing that it becomes accessible at a public access PC at the courthouse. So the standard practice for the clerks is that at the time of the hearing in real time, they should be setting the exhibit to full so that the court can conduct the hearing and do what needs to be done. And they seal it in real time at the time of the hearing as well. So you may have had some overzealous court clerks who were doing property docket prep who may have gone in and sealed them ahead of time. But the directions given to the clerk's offices were to work with them in real time at the time of the hearing as the court is interacting with them, and they're ordered sealed at that time so that they're protected. But when they're sitting in the file prior to the hearing, as long as they haven't been marked by the court clerk as full or ID, but in this case it would be full, then nobody can see them who comes to use the public access PC. So they're protected at that point in time, and then further protected once they're marked as full by sealing them. And of course, as Judge Bader suggested, you can always ask the judge to order them. If the clerk has sealed them prior to you being able to interact with them in court, you can ask the judge to order them unsealed for the moment so that everyone can see them. It's a click of a button. It's meant to be done in real time, and then order them resealed as soon as the hearing is over. So all the clerks should be able to do that. They have access to that.
So just to make sure I understand, and to Judge Spader's point and some of the concerns that I've had over the last, it sounds like really then if the clerks are doing what they're supposed to be doing, the only real point of vulnerability in terms of third-party access to the information would be in the event of like a overmarking or an off-marking where the matter is taken up. Documents are then made exhibits, but the matter doesn't conclude, so they don't automatically, or not automatically, but they don't get sealed as a matter of practice.
No, they do get sealed as a matter of practice.
If the hearing doesn't, let's say it doesn't conclude. Let's say you take it up, they get made exhibits, and while discussing it, borrower asks for mediation, and you say, okay, we'll send it to mediation and come back. It would have to be. It may not. Let me back up a minute. Would it be more appropriate to just ask that they be sealed if the matter doesn't, if the judgment hearing doesn't conclude, so that there's no point of?
That would probably, to err on the side of caution is always better. I mean, this can be read that at the time of the hearing they're going to be sealed, but if you have any concerns at all, then you should ask for it. What I'm hearing, folks, and I don't want to, this is a great discussion, and I think it's because the question that Jeff brought forward on its face was like, oh, that makes absolute perfect sense, and it still does. Hearing the additional input, though, obviously it's a deeper issue, and we have at one end of the spectrum the not sealing, and then I'll call it the Spader end of the spectrum of why it would be that you'd want it sealed early. It sounds like based on the language in here, though, at this point, we aren't making any, or there's no consensus to make any recommendation to the change in the language, rather perhaps reminding the clerks of the standing order and making sure that the rule is applied in accordance with the standing order. Is that a fair summary?
I would agree with that.
Yeah.
And then I think we can also, and this is the part that when the standing order does, although maybe it should be bolded, I'm partially kidding, all documents must be e-filed and all electronic exhibits must be uploaded by the close of the short calendar marking period the week prior to the short calendar. But there have been plenty of people who are very unhappy when they show up on Monday with matters that they've just filed exhibits on, and they but they'll learn about the standing order that way.
I will, Your Honor. It's also, it exists, these are the short calendar standing orders.
Yeah.
The standing order actually exists in a separate form as
Oh,
well.
I know. Oh, I know.
So yeah.
I'm well aware. And I know the folks on this call are well aware.
Yeah, yeah. So it
I
ties
just,
back
that was
to
more
the,
tongue in cheek, I suppose, but are there, and this is, if we don't get through anything else, that's fine, but I do want to make sure, other than that, which was a very important discussion, were there any other areas of the proposal? And thank you, Jeff, for putting this together because it provided us with a springboard for everybody to weigh in on. Is there anything else that anybody wanted to weigh in on the proposals that are included in this redlined copy of the standing order? Okay, I'm hearing nothing. So with that, would it make sense for us to just modify as it relates to that paragraph, take those suggestions out? Or it's not really a suggestion, it was more of a question, and a good discussion resulted from it, and indicate, or basically provide the proposals that are in here with an additional suggestion that we just talked about of making sure that all the clerks, including obviously the new ones, are made aware of the need to apply the standing order. Does that make sense for an action plan for us? I'll entertain a motion. How's that? Maybe someone will speak that way. I see, it looks like Judge Rohraback's talking, but he's muted. You're still muted.
But I wasn't talking.
Oh.
I'm not chewing gum either, teacher. I was at the public.
I just assumed everyone had heard enough of my voice, so I was trying to stay silent, but I would so move.
All right. Is there a second?
I'll second.
Any further discussion? All those in favor? I see the hand raises.
Aye.
Any
Aye.
opposed? Any abstentions? Attorney Salato, did you vote? Did you vote yes?
I voted yes, yes.
Okay. All right, great. So we have an action plan for that. All right. I just want to go over the easy one first, which is, so I'll entertain a motion to take the one agenda item out of order, and that is the status of the proposals to the branch, because it's a quick report to you folks. Is there a motion?
So moved.
Second, anyone? Any discussion? All in favor?
Aye. Go for it.
Okay, great. So I just wanted to let you know that with Becky's assistance, we did put together the proposal of the two suggestions that we had voted on, which I printed off. But now that I'm on the phone with you folks, see if I can, or in the Teams call, let me see if I can pull it up. One of them was simple, we thought was a simple one, which was the proposal to see if we could get the clerks to flag the bankruptcy that was suggested by Judge Morgan when she was still with us on the committee. And let me just see where that disappeared to. And it's under review. She's had some questions for us. We've gone back and forth a little bit on it. And I know that I have a new email from her that came in while we were in this meeting that I have not had a chance to take a look at because, of course, I'm with you folks. But hopefully that will be something that we will get a positive on, although she is delving into that question. The other one is we also submitted the suggestion that, and I'll just read it to you. There's confusion in the remote foreclosure docket because participants are placed in the waiting room until a judicial employee joins the remote event, which doesn't usually happen until the docket starts. This is true in particular with self-reps, but also for some attorneys other than the regulars. The practitioner committee members report that there's a regular dialogue before the clerk arrives and even after, but before court starts, with people expressing confusion. The committee recommends that a clerk join the remote event 15 minutes early, announce what the docket is so that people are aware they are in the right place, and also suggests that the clerk when the clerk joins, he or she put up a screen share of a background message with the information so that people with video, the video users, know they're in the right place. And we suggested a simple message that just indicated the docket, the date, and that this is the foreclosure short calendar docket. And again, Judge Bellis had some questions about that and the concern about whether asking the clerk to join early would create a staffing difficulty. I think we responded to that, which hopefully addressed her question, but I don't know that yet. So as soon as we get some sort of guidance on that and see what she has to say about our proposal, Judge Bizzuto did ask that we get Judge Bellis's input first before we sent it up to the Chief Court Administrator for their approval. Becky, did I leave anything out on that one?
That covers it, Your Honor.
Okay.
And Your Honor, I think that may be ultimately an issue with Teams in some way, because I know for a long time you could log into the hearing whenever you wanted and it would take you into the hearing. There just wouldn't be anyone else there. I think that something changed with Teams where until the person organizing the meeting starts it, you can't get into the meeting. So I know that previously, at least as far as mediations went, we could get into the mediation as early as we wanted to. We would just be the only one there. So I hopefully there's some way that they can resolve that.
Right. And it's funny because there are gremlins in the system, because we had a situation that Attorney Pocklington, I'm sure, will recall, where frequently I couldn't get into the hearings because he had gone in first and somehow that made him into the organizer and he had to allow other people in, and it created a whole big issue. So yeah, I know that there are issues there. So we'll see. Hopefully it's a simple fix, but nothing's ever as easy as we think. So so with that, the last item we have under old business is the quality of life improvement suggestions. And Becky received whatever you folks submitted. Becky received them, and we have the bullet point. We figured rather than circulating that, we would just address them during the discussion now. We'll see how this discussion goes, because there aren't a lot, but there are a few bullet points. And so if it looks like it's going to take us too long to get through it today, perhaps we can at least go partway through and then address the other issues at the next meeting. So I'll throw them out there and open each one up for discussion. The first one is, and I'll just read it the way that it was summarized by Becky. Be mindful of self-represented parties' possible difficulties with using remote technology. I mean, that's kind of an obvious issue. But I get it, and it doesn't always happen. So please, folks, anyone want to weigh in on that one?
No, nothing's obvious. We always need to be mindful and be reminded on a regular basis. Even, you think you do well, you still got to remind yourself regularly to treat self-reps, where they're at, and be mindful of that and not to forget that.
Yeah.
Good suggestion.
But anything specific?
Seen some issues in calendar, specifically in Hartford, where self-represented individuals will call into the hearing because they're provided the call-in number, but they end up being, this is kind of relates back to the fact that generally everyone is let in right about when the calendar is about to start, when the call is about to start. They're often instructed that they need to be present by video. But there's really no one to assist them with trying to get that to work. So their case just gets called, marked, and then moves on with the calendar. I know that I think that at least one or two times we've had individuals call in who are told that they need to participate by video, and then they get off of the call and never show up again. So I'm mostly just concerned that there's no way for them to try to troubleshoot this or work out how they can then get back into the call, and they end up just giving up and not logging back into the hearing. So
the clerk doesn't assist.
It's usually during the actual call of the calendar, and the particular judge in Hartford just kind of moves on and tells them that they need to be present by video and just moves on to the next case. So it's a little bit tricky because it's hard to troubleshoot someone's issues while the calendar is going on, but I just have had concerns specifically because it appears that, I don't know if it's necessarily on our cases or not, but I've seen situations where someone will call in, say that their video is not working. They're told that they have to be on by video, and then their phone number disappears and they never get back on again. So,
Okay, I just want to make
wanted
sure,
bring
because
that to the court's attention.
no, that's a very valid point, though, because the practice was that the clerk was usually there, but you're saying it happens now, it's happening like just in the middle of the hearing,
Usually,
because we usually would just
what-
have the clerk
Yeah,
help.
what used to happen when people could get in before the hearing started was that the clerk would come on, say, I see a phone number here. The notice that you received says you need to participate by video. If you need the link, we'll send you the link. But because everything is kind of starting when the call starts, there's really not that opportunity for anyone to troubleshoot their teams on the fly, I guess.
Oh, I got
so
you.
it makes it a lot more complicated.
Okay. All right. Thank you for that. Anyone else? All right. If you think of anything, obviously feel free to shoot it along, but that is an important one. And again, I know it seems like an easy one, but as Judge Spader said, it is necessary to keep reminding yourself to be mindful, both for the bench and for the other parties. Second one is also a good suggestion, and I think that hopefully we are addressing this with some of the work we're doing, need for plain language notices. But does anyone want to weigh in on that with any specific suggestions beyond the standing orders that we've been talking about?
I think the biggest confusion people get is that they receive a notice that the motion has been marked ready, and then they receive another notice that says your hearing scheduled for this date. So I mean, I don't know that there's really a way to make that any clearer, but I know that that's where a lot of confusion comes from.
Yeah, fair point. Well, we can at least raise the issue. And again, I don't know what, if anything, immediately can be done based upon the way the systems work, but it's important to bring the issues to the forefront and see if there are things that perhaps can be adjusted. Let's see. All right, this one I'm going to need a little help with. Discrepancy between the adequacy of the property inspection information and the charges associated with those inspections. I don't know whose that was, but if you want to weigh in.
That, I have to admit to that one. It was in response to Judge Rohrbach's mention about, I think it was 2 meetings ago, around what are the charges that are on the affidavit of debt. And I believe that Judge Rohrbach asked, especially in a non-appearing situation, well, was the property, what was the result? Was it vacant? Was it abandoned or something? I think I'll obviously be corrected, but and my only observation was that the reports themselves are all, like, each time a property is inspected, for that $15, for that $20, whatever it is there is a report generated by somebody in the field, and it includes the conclusion vacant or abandoned and for like what reason, or occupied. Snowstorm was 5 days ago, still hasn't been shoveled yet. I believe it's, vacant. So to the extent I guess what that is, it's like a very delayed answer to Judge Rohrbach's question from 4 months ago, that there is documentation to substantiate whatever happened on the inspection, and furthermore that it addresses not appearing defendants, possibly.
All right, so Judge Rohrbach, does that answer your question?
I'm not sure. I can't remember yesterday, let alone 4 months ago. I think my hang up is, I just asked the plaintiff's attorney, is somebody living there, or is nobody living there? Because if somebody's living there, that enters into my thinking potentially in the middle of winter, whether I'm going to, have a law day on this day or a sale day on that day. It's just a point of information that I think is helpful. So, and I guess an inspection report certainly sheds light on that question.
Yeah.
Good. The more we know, from my perspective, the more I know about what's going on at the place and whether there's people, human beings, that are going to be displaced ultimately, or whether they've already given up the ghost, we're just picking up the pieces.
And what it is that each month someone has gone to the property and made that assessment.
Yeah, no, I understand.
So, it exists, if nothing else. And I've spent probably too much of my career on those field services issues.
All right. Does anyone else want to weigh in on that one, or does that it sounds like a pretty finite issue? But I just want to make sure. All right. The next comment was appearance of impropriety or overfamiliarity with plaintiff's bar at short calendar. Open for discussion.
I've a few times seen some people catching up with each other that they hadn't seen in a while. And it just, in the moment of a judge talking to a lawyer who then is going to ask for foreclosure while the pro se is sitting there, I completely get the civility between the bench and the bar, obviously. That's why I'm here today. In the moment, it felt, we can get used to it. We forget how clubby we feel to someone who's coming in, there's their first time or second time in court, how we all seem to know each other. And so I just, it was just, it doesn't happen much, but I just thought it was worth noting.
So what would so for a quality of life suggestion,
Sure.
What would the suggestion? I mean, it shouldn't happen in a chummy way. You're right. That's on the judge. We're supposed to not do that. But what would be your suggestion for a quality of life improvement to that issue?
I guess it's just a reminder to be mindful of speaking to one party off the record and not the other, or at least being mindful of the appearance of how that looks when you're talking to the lawyer for one side versus the other. That's all. And the thing is, I feel bad because it's remote and we miss some of the interpersonal connection, but nevertheless, I can imagine from the pro ses that we talk to that it adds to a feeling of being an outsider at a vulnerable moment. So
Anyone
I would just
else?
say, just be cool with the small talk beforehand. You want to talk to both lawyers? Sure. But the pro ses, it's hard.
Mm-hmm. Anyone else?
I just want to briefly come to the defense of the plaintiff. Not that Attorney Gettys is assaulting them, but my experience has been almost uniformly the sensitivity of the plaintiff's bar to the job that the judge is called upon to do and to the circumstances of the self-represented party. In most cases, I salute plaintiff's counsel for recognizing that the court is trying to let someone down as gently as they can in a very difficult situation and to work with that party as much as they can without unduly prejudicing the plaintiffs. That's been my experience, and it makes the process a whole lot more digestible.
And I only wish it were easier to explain that to our clients.
Well,
So,
and you know what? Thank you for taking it on the chin, because in the fullness of time, it's really for the good of everybody.
And I appreciate that comment. And again, I'm just my understanding of Attorney Jentz's comment, and please correct me if I misunderstand this, but was more akin to, and I'm not asking you to give names, but it sounds like based on specific experiences, perhaps somebody saying, hey, how's your wife and kids? Or, oh yeah, did you enjoy that vacation last week? That kind of stuff. More of you said chummy, so I'm thinking the more pally kind of familiar discussion. Is that what you were talking about?
How's your dad? That kind of stuff.
Right.
And it's no one on this call, to be clear.
All right. Thanks for that. But we won't go any further with we don't want to call anybody out on a public meeting, but I appreciate that. So you're right. So anyone else on that issue? All right, moving on then. These are all they sort of speak for themselves, but some of them may require some weigh-in and discussion. Lack of consistency in processing and data entry on motions to substitute.
I think I know exactly where this one is coming from.
Yeah, and I will fess up to this one because
I'm not
there
trying
is
to call anybody out.
No, and this is one of those things that I think you really only become aware of if you look at how different courts treat this and different clerks' offices handle it. And it is an area where there is very little consistency with how e-filing in Edison is used by the branch. Just to summarize it, because it's still fresh in my head from when I wrote it a couple, after our last call, is there are three primary ways motions to substitute, particularly motions to substitute plaintiff, are handled in the e-filing system. In some courts, the substituted plaintiff simply replaces as PO1, and it's as if they were the plaintiff the entire time. In other courts, it's added as a PO2, and the first plaintiff is listed as removed, so there's no appearances for counsel of record because they're no longer they're no longer a party. The third way it is often done, and probably the most logistically challenging, is it's added as PO2, and the PO1, the prior entity, remains in the case, their counsel remains in the case, and it's not unheard of for after 3 or 4 substitutions, including due to service transfers, for there to be appearing counsel of record that no longer have an interest in the case because the party that they represented is 3 plaintiffs ago, and they've not only has the plaintiff changed, but the firm that the current plaintiff chooses to retain is a different firm. But because of the way Edison works and the way certification of pleadings is done under the practice book, you get attorneys that no longer really have an interest continuing to get pleadings, continuing to get court notices, et cetera, because they're still counsel of record for a party, even though they're no longer an operative party.
Okay, so you're saying that's an Edison issue.
I think so. I think it's partially an Edison issue and partially a how substitutions are handled on more of a data entry than a system Edison issue, if that makes sense. There's definitely a lot of inconsistency there, at least from my perspective. I don't know whether the other practitioners have seen the same thing.
I have,
So, but it's a
couple things to
back
add
of the
to this as
house
well.
issue is what I mean.
Yes.
Okay,
Yeah.
okay.
In addition to what James was saying, there's also court-specific issues with regards to this. I know certain courts, when they grant a motion to substitute, will indicate in the order that they're requiring that a substituted complaint be filed to properly reflect the plaintiff and the assignments to the plaintiff. I know some courts just grant the motion to substitute and don't require this. Lately, we've been having some issues where, specifically in Hartford, the order itself did not require a substituted complaint. The case gets to a judgment hearing, and the court indicates, I don't see an amended complaint or a substituted complaint. I need to mark this off. So the orders.
Just for the record,
not
I'm not in Hartford
consistent, so.
anymore.
So what,
I
Judge
didn't mean
Spader,
to
what do you
take any
think?
shots at Judge Peo. This is not a Judge Peo issue. This is I think a consistent issue. I know specifically New Britain always requires substituted complaints to be filed when we file a motion to substitute. It's in the order. It's very clear. And we have no issue doing it if the court is requiring it. It's just a question of whether or not we're aware of it before we get to the judgment hearing, and then the case gets marked off because there hasn't been a substituted complaint filed. So it sounds like there's even more motion to substitute issues than I was even aware of. So I think it's definitely an issue that's come up, I know, pretty frequently in the last few weeks. I don't know specifically with regards to our files, but I know that it's happened with some with James's firm. So and other attorneys as well that don't have as many files as we do.
Attorney Spader, do you have a point of view on that question?
I have a point of view on many questions. Yeah, on that one specifically, again, it's an issue that I've considered. I haven't come up with what the easiest solution is. I believe that when the motion to sub comes in, I would like the clerk's office to be adding a P2 and removing the appearance on the P1, but
no, I was talking more about whether you think they need to file a substituted complaint when you grant a motion to substitute. I
don't think they do, quite honestly. I think
I don't think so. I had one this week, and my clerk was saying, "So why do I need a substitute?" I knew who the plaintiff is, but while we're on the quality of life, though, I had one this week where the named plaintiff had no interest in the mortgage and note at the time the action was initiated. It was already owned by the substituted plaintiff, but it was brought in the name of somebody that had it before the action was even initiated. It's like, hello, why don't you check before you start the action to see who the current owner of the note and mortgage is, so you don't need to substitute for that person at a later date. It's like there's like this time lapse photography thing going on.
And just to be
Whatever
clear, I
it's
don't have a
worth.
position either way on whether or not we need to file a substitute complaint. I just want to know what we need to
understand.
do in
No-
advance. So that's
Yeah.
No,
that's
I
my
And I will
bigger concern,
say,
is just consistency.
prior to when I was first in New Haven, I know that that prior to me, there was generally they were requiring substitute complaints. So when I first started, I think for the first couple of times, like, okay, I did what was done before me. And then some smart plaintiff's lawyer, maybe one of the ones on this phone call, I don't know, but somebody filed a request that they not have to file the substituted complaint, which made perfect sense to me, and I granted it. And so that's why I understand, and it's always been it can be a frustration. I know even from being on the other side of the bench that we do have our courts in some respects do things not the same. It's different court by court, but for whatever reason. And so I think, would it make sense to put together a recommendation for uniformity that we can submit as a proposal?
I agree with
Something
that.
was something that, well, why don't we figure out what we want to recommend, and I'll be more than happy to type it up, because I'll fall on the grenade on this one, because this is something that's
Great.
been a pet peeve of mine for quite a while. So which way do we want to suggest that things go? Should, on a substitution, should it be a complete replacement, or should it be a add but then remove? Which I think is my personal perspective is add the new plaintiff or new party, add the appearance of their counsel, remove the replaced party as a party, but not remove them, but not completely replace them. So there's still a history, the PO1, PO2, PO3. So there is a clear record of the life of the case.
Is everybody comfortable with that proposal?
I like the life of the case shown there.
Yeah, it preserves the history, but also keeps the primary or the active parties in. All right, James, why don't you do that then? And you can put something together. We'll get it circulated to everybody for review and discussion. And if you think you can get it done before our next meeting, then we'll have it on the agenda. We'll at least put it on as, we can put that on as, I guess it would be new business to address the proposal relating to motions to substitute.
And remember something about these meetings, they are being broadcast. The minutes are out there. I mean, even if we're discussing something that seems like hyper local and hypersensitive for one specific issue, it could be information we're putting out there that is helping others who might be listening to it and hearing it. So it's not that something is too hyper specific to one case. It could benefit and help others who hear this discussion. Hearing this discussion is one issue, though. Judge Bale, do you have a party waiting for you to get back into the bench on? Like,
yeah, I do. And I have 7 minutes before I have to go back out. So here's going to be my suggestion. I think we've handled a lot today, and it is almost 4:30. I want to be respectful of everybody's time because the meeting has gone longer than we anticipated it would today, because we had a lot of good things to talk about. But we didn't fully expect to get through this whole quality of life list. I'd like to keep this on old business, and we'll pick up with the next bullet point for the next meeting and continue the discussion. Is everybody okay with that?
Yes.
Great. But thank you, Judge Fader, my timekeeper. I appreciate that. With that, is there any new business we need to address? Hearing none, I would entertain a motion to adjourn.
Motion to adjourn to get Judge Bale back into the courtroom.
And I'll be 6 minutes ahead of time. All right, all those in favor? Thank you so much, everybody, for a very productive meeting. Becky, I'll touch base with you after, and if you can get a notice out for the next meeting, and that would be great. All right. Bye, everybody. Thank you.
Thank you.
Thanks.
Bye.
Thank you.